He lost his $8,500 deposit. Then the judge tripled it. A contractor lost his entire $800 security deposit. What he didn't expect was to walk out of court owing $25,500 instead. For 11 years, the contractor had built his reputation the same way he built everything else, carefully and on time. He ran a mid-sized renovation business out of the same county where he'd grown up, and when the school district offered him a short-term lease on one of their unused administrative buildings as a staging ground for a larger municipal project, it felt like a professional milestone. The lease was straightforward: $8,500 security deposit, a 6-month occupancy period ending in March, and a requirement that the premises be returned in the same condition as received. He signed on a Tuesday. By Wednesday, he was already moving equipment in. The school district's facilities manager, a woman who had overseen district properties for nearly 2 decades, processed the paperwork without concern. The building in question was a former records annex, mostly concrete floors and fluorescent lighting, functionally empty for 3 years before the lease. Both parties agreed on a move-in inspection. Both parties signed the walkthrough report. Then 6 months passed. When the contractor vacated in late March, he left what he believed was a clean building. He patched the walls where he'd mounted temporary shelving, swept the floors, and hauled away every piece of equipment. He expected his deposit back within 30 days. After 60 days of silence, he called. After 90 days, he hired an attorney. His case was direct. He had fulfilled every term of the lease. He had documentation, photographs taken on his final day, signed receipts from the waste removal company, even a handwritten note from his foreman confirming the walkout time. The district had held his money for over 4 months without explanation, without an itemized deduction notice, and without any communication citing damages. Under state commercial tenancy law, that silence had consequences. He was suing for the return of his $8,500 deposit plus statutory interest and attorney's fees. The district's attorney had a different story. According to the facilities manager, the building the contractor returned was not the building he had leased. She described a cracked section of concrete flooring near the loading bay, damage consistent with heavy equipment being dragged rather than lifted. She cited an HVAC assessment completed 2 weeks after vacancy that found particulate contamination in the ductwork attributed to sawdust and construction debris. And she pointed to the loading dock's rubber bumper strips, 3 of which had been torn free and were found discarded behind the building's utility shed. Total remediation estimate, $26,400. The district wasn't just defending against the deposit claim. They had filed a counterclaim for $25,500. The damages total minus the deposit they'd already retained. The courtroom shifted when the district's contractor took the stand. He was composed, credentialed, and specific. He walked through each line item with photographs, timestamps, and invoices. The concrete damage alone cost $11,200 to resurface. The HVAC cleaning ran $8,900. The dock repairs came in at $6,300. He had no financial interest in the outcome. He was simply the man the district called to fix what had been broken. But then came the deposition transcript. The contractor's attorney had subpoenaed maintenance records from the district's own facilities database, records the district was required to retain under state administrative code. And buried in those records was a work order dated 8 months before the lease ever began. It described the same concrete flooring near the loading bay as having stress fracturing consistent with age and water intrusion. It recommended resurfacing. That recommendation had never been acted upon. The HVAC records told a similar story. A filter inspection logged 14 months prior noted moderate debris accumulation requiring attention. The district had deferred both repairs, then leased the building, then attributed the pre-existing conditions to their tenant. The judge was quiet for a long moment after closing arguments. She found in favor of the contractor on the deposit claim and ordered the full $8,500 returned with statutory interest, bringing the total to $9,040. She dismissed the counterclaim entirely. In her ruling, she noted that a landlord cannot withhold a deposit or pursue damages for conditions they failed to disclose and, in some cases, had already documented before the tenancy began. The district's remediation costs were real, but they were not the contractor's debt to pay. The facilities manager retired 6 months later. Whether that was connected to the case, no one said publicly. The contractor told a local trade publication that the legal fees had cost him nearly as much as the deposit itself. and that he would think twice before leasing from any public institution again. The district quietly updated its pre-lease inspection protocols, which leaves the question hanging in the air, the way these things always do. If the school district had simply returned an $8,500 deposit they had no right to keep, would anyone have ever known what those maintenance records contained? And who else might they have done this to before?